The story does not begin with a crime, or with a victim, or even with a name. It begins with paper. Paper stamped, filed, copied, and stored in places designed to outlast memory. According to records, thousands of pages accumulated quietly over decades, moving through offices, agencies, courtrooms, and private law firms. Each page carried fragments of information, fragments that, on their own, appeared ordinary. Travel logs, contact lists, financial transfers, plea agreements, sealed filings, memos written in neutral language. Reports suggest these documents were meant to clarify events. Instead, they seemed to do something else. They created distance. Jeffrey Epstein's rise into elite circles did not follow a straight or transparent path. According to records, his early career left more questions than answers. Financial ties appeared suddenly. Properties were acquired without clear explanations. Associations formed quickly with individuals who wielded power in politics, finance, academia, and royalty. Documents indicate that by the time law enforcement attention intensified, Epstein was no longer just an individual under investigation. He was a node in a much larger network, one protected not by a single institution, but by many overlapping systems. When documents first surfaced in the public record, they carried the promise of revelation. Court filings released names. Depositions described events. Flight logs suggested patterns of movement. Yet, reports suggest that for every document released, others remained sealed. According to records, some files were withheld under claims of privacy, jurisdiction, or national security. Others were delayed through procedural motions. Time passed. Public attention shifted. The documents remained. The language inside these files is often careful, almost clinical. Words like alleged, claimed, and unverified appear repeatedly. Documents indicate that even when patterns emerged, they were described as coincidences rather than conclusions. Investigations were narrowed in scope. Charges were limited. Plea agreements were negotiated behind closed doors. According to records, one such agreement significantly reduced exposure, not only for Epstein, but potentially for others whose names appeared in related material. Reports suggest that law enforcement agencies possessed more information than was ever presented publicly. Internal memos referenced additional witnesses. Draft indictments were written and then revised. Lines of inquiry were opened and then quietly closed. According to records, decisions were justified through resource constraints, evidentiary standards, or jurisdictional limits. Each explanation sounded reasonable. Taken together, they formed a pattern of restraint. The documents also reveal something else: silence. Names appear without context. Meetings are referenced without details. Flights are logged without destinations explained. Financial transactions are recorded without purpose specified. According to records, this silence is not accidental. Legal language is designed to include what is necessary and exclude what is not required. What is excluded often matters most. As years passed, journalists, lawyers, and researchers attempted to reconstruct the story from fragments. Reports suggest they encountered resistance at every step. Freedom of information requests were denied or delayed. Court transcripts were heavily redacted. Witnesses declined to speak, citing legal advice or non-disclosure agreements. According to records, some agreements were signed decades earlier, their terms still binding. When Epstein was arrested again years later, the documents multiplied. Search warrants produced inventories. Financial records were reviewed. Electronic devices were seized. According to records, investigators described a volume of material that would take months, perhaps years, to analyze fully. Public expectation rose. This time, many believed, the documents would change everything. They did not. According to reports, key materials remained under seal even after the arrest. Motions were filed to protect third parties. Judges weighed transparency against potential harm. The balance often favored caution. Documents indicate that while some names became public through civil litigation, others remained obscured. The story advanced unevenly, revealing details while concealing structure. After Epstein's death, the documents took on a different weight. According to records, investigations shifted from criminal prosecution to administrative review. Questions about accountability grew louder. Who knew what and when? Who decided which cases moved forward? Who approved agreements that limited exposure? The documents held possible answers, but access remained limited. Reports suggest that internal reviews were conducted. Agencies examined their own actions. Findings were summarized, not fully disclosed. According to records, errors were acknowledged in broad terms. Failures were described as procedural, not personal. Responsibility was dispersed across departments, offices, and time periods. No single decision was identified as decisive. The documents that were released often arrived stripped of emotion. Victim statements were reduced to excerpts. Timelines were fragmented. Context was missing. According to records, this presentation shaped public understanding. The story appeared complex, confusing, difficult to follow. Complexity can discourage scrutiny. Confusion can dull outrage. In courtrooms, documents speak louder than voices. Yet even there, their impact was limited. Reports suggest that evidentiary standards prevented certain materials from being considered. Statutes of limitation closed doors before arguments could be heard. Jurisdictional boundaries divided cases into smaller, less powerful parts. According to records, what could not be addressed in one venue was often not pursued in another. The international dimension added further layers. Epstein traveled across borders. Accounts were held offshore. Properties were located in multiple countries. According to records, cooperation between jurisdictions was uneven. Requests for assistance moved slowly. Legal systems differed in what they required and what they allowed. Documents accumulated in parallel, rarely converging into a single, coherent case. Financial records hinted at scale, but not purpose. Transfers were logged. Entities were named. According to reports, investigators traced flows of money without always determining intent. Some transactions were described as legitimate business. Others remained unexplained. Documents indicate that without direct testimony or corroborating evidence, conclusions were avoided. Throughout this process, powerful institutions continued to function. Universities accepted donations. Foundations hosted events. Political campaigns received support from associated figures. According to records, background checks did not always capture reputational risk. Documents that raised concerns were sometimes classified as unproven or irrelevant. Life continued. Media coverage surged and receded in waves. Each new document release sparked attention. Each lull allowed interest to fade. Reports suggest that sustained scrutiny was difficult to maintain. Legal processes move slowly. Audiences move on. According to records, time became an ally of silence. The phrase, "according to documents," appeared frequently in reporting. It signaled authority, evidence, credibility. Yet documents alone do not interpret themselves. They require context, analysis, and, often, courage. Reports suggest that interpretation was constrained by legal risk. Defamation concerns limited what could be said. Editors weighed public interest against liability. As years passed, the documents did not disappear. They remained archived, cited, referenced, but their presence did not produce proportional change. No sweeping reforms followed. No comprehensive reckoning occurred. According to records, policies were adjusted quietly. Training was updated. Oversight mechanisms were reviewed. These changes were incremental. Victims sought recognition and accountability through civil suits. Documents played a central role. Depositions, affidavits, and exhibits formed narratives. Yet even here, settlements often replaced verdicts. According to records, settlements resolved claims without establishing facts in a public forum. The documents remained part of a sealed record. The question persisted. How could so much information exist and so little change follow? Reports suggest that documents can expose actions without altering systems. They can reveal failures without assigning consequences. According to records, institutions are resilient. They absorb criticism, adapt language, and continue. In the end, the Epstein files stand as an archive of proximity. They show how close information came to power and how carefully it was managed. They demonstrate how legality can coexist with injustice. According to reports, the documents did what they were allowed to do, and no more. They changed narratives briefly. They shifted public perception temporarily. But structurally, they altered very little. The systems that produced them remained intact. The silences persisted. The unanswered questions remained unanswered. And so the files remain. Not as a conclusion, but as a record of limits. Limits of disclosure. Limits of accountability. Limits of what documents alone can accomplish in a world shaped by influence, caution, and power.